I'm Jeff Butler, and this is Brittany Partridge. We're lawyers at the Butler Kahn law firm, and we'll talk today about a motorcycle accident settlement that our firm recently obtained in the amount of $519,000. So we'll start out with Brittany telling us a little bit about the facts, what happened out there on the roadway.
So in April of last year, our client was on a motorcycle on his way to work. He was on Bethesda School Road in Gwinnett County. The at-fault driver was leaving her neighborhood, and if we pull up the police report, we can see a diagram of what's to come. So as our client is driving down Bethesda School Road, the at-fault driver is stopped at Amalfi Way, about to pull out. Well, she pulls out directly in front of our client. And as you can see on the police report, the diagram shows our client, Mr. Ramos, traveling down Bethesda School Road, and then winds up hitting the front left side of the at-fault driver's vehicle. And we actually have some photos of that damage.
So if we look here, Brittany, we're looking at the motorcycle coming down on the page, and then the car pulling out in front, and the diagram of the police report. Is that right?
That's right.
All right. And you asked for pictures of the car.
Yes.
Okay.
So next we can look at the damage to the at-fault driver's car. So as you can see, there's pretty severe damage to that front left area where Mr. Ramos actually hit it with his motorcycle. And witnesses on scene said that Mr. Ramos actually slid under the at-fault driver's vehicle. And so we actually have a second photograph which shows even more damage. And this is a residential road. Mr. Ramos was not traveling very fast, but it was still a severe collision, which resulted in pretty severe injuries. So part of our case, we hired somebody to do medical illustrations, which if we can pull those up.
Yeah.
So medical illustrations are basically a drawing of the injuries that our clients have. So Mr. Ramos had pretty severe injuries. He had a grade 4 liver laceration, which caused internal bleeding. He had a broken wrist, and then he also had a very large wound to his thigh. And both his wrist and his thigh laceration or thigh wound required surgery.
So here we're looking at, this is just the wrist surgery, right?
Yes, so this is just the wrist surgery where Mr. Ramos had hardware inserted into his wrist that is going to be permanent for him for the rest of his life.
This is what you'd call a open reduction internal fixation?
That it is.
Okay, I'm proud of my big words.
Yeah.
Okay, and then you mentioned the thigh surgery, I think.
Yes, so because of the size of Mr. Ramos's wound, there was actually some of the tissue that started to die off or become necrotic, and the surgeons had to go in and actually remove that tissue so that it wouldn't cause further injury or infection. And so tissue was cut away and he was stitched back up, and then a wound vac was applied on his thigh to help the healing of the large wound.
Yeah. So in a case like this, one of the things we'll do, we can take down those images now. One of the things that we do is obviously to look for insurance. We need to know what amount of money is out there to be available to compensate our client for their injuries, their pain or suffering, and everything that they've been through. And most people know this. I think the first place you look is the at-fault driver's insurance. So here, the driver of that red car, I think it was like a Nissan Juke or something like that. What insurance did they carry? But then oftentimes we find that the at-fault driver doesn't have enough insurance. At our firm, we handle principally significant injury cases. A lot of times they're wrongful death cases. And so it's not uncommon for us to find that the at-fault driver didn't carry enough insurance. Here, I think the at-fault driver carried, was it $50,000 in insurance? $100,000 in insurance, which still isn't enough given all that our client had been through. And so we look for other insurance. Now, this is kind of an interesting situation because it's a motorcycle, not a car, and because our client was on someone else's bike. So that matters in a couple ways. After going to the at-fault driver's insurance, which we call liability insurance, we'll look for underinsured motorist or insurance. First, you look at the injured person and say, did you have it? A lot of people have insurance and don't know it because anytime you buy regular old car insurance or auto insurance, the insurer is required by law to offer insurance. So some people buy it and don't even realize it or don't know that's what they've bought. But in this case, our client didn't have it, which is too bad because insurance is insurance for you. It's insurance to help you if the other driver doesn't have enough. But here he didn't have any. So next we look to the owner of the motorcycle. If there had been insurance there, we could have used that. But again, there was no insurance there. So that left us with the only pocket of recovery being this $100,000 in liability insurance, which wasn't going to be enough. In this case, we made a offer, a special offer under a case called Holt to the liability insurer and gave them a chance to pay the $100,000, which is all the coverage they had, and get out of the case, but they failed to accept our offer. And for that allowed us to proceed with the case, and it gave us some leverage for subsequent negotiations. But now I'm kind of getting ahead of us. Brittany's going to tell us about some of the challenges we faced in this and in other motorcycle cases.
Yes, so one of the challenges in this case was that Mr. Ramos was on a motorcycle. We find that sometimes juries have a bias against motorcycles, and that's just something we have to deal with. But to push that bias potentially even a little bit further, Mr. Ramos actually didn't have a motorcycle license or permit. And in the state of Georgia, you're required to have a motorcycle license or permit when you drive one. So we risked the chance of a jury saying, well, Mr. Ramos shouldn't have been on a motorcycle when he wasn't licensed to drive one. And so therefore, he's partially at fault or fully at fault for the collision. And that was just a risk we had to keep in mind when we started negotiating with the at-fault driver insurance company, or when we came time to send a demand. And Jeb's going to tell us more about our demand process.
Yep. So in a case like this where we have the leverage of an insurance company that failed to accept our offer, we, after we've done some work and have established that the injuries and the loss exceed the value of the policy, then we can try to collect over that insurance limit. Not every case presents that opportunity, but this one did, and Brittany did a great job working with Mr. Cassio to get those medical illustrations that showed the injuries. We had the workup showing the other person was at fault. So it was time to make an offer. Our client wanted to see if we could get the case settled for a reasonable amount. So we made an offer pursuant to two different Georgia statutes. And if we can go now to bring up the laptop behind Brittany and I. The first is OCGA, that stands for Official Code of Georgia Annotated, Section 9-11-68. It's called the Offer of Judgment Statute sometimes. And then the second we'll talk about is the UDIA, or Unliquidated Damages Interest Act. 9-11-68 says if we make an offer and the jury and the court ultimately award an amount that is 125% of that or more, we can collect, our client has the right to collect our attorney's fees on top of the award if the offer wasn't accepted. Let me run through that again in what I hope will be a less confusing sequence. If we make an offer pursuant to Rule 68, 9-11-68, and the insurance company doesn't take it, but then we beat that offer by 25% at trial, then the jury can also award our attorney's fees, which is usually an additional significant percentage on top of that the insurance company has to pay. So basically, it's a way to put pressure on an insurer to do the right thing and pay the fair amount of a claim. We also will often use the Unliquidated Damages Interest Act, or UDIA, which says that if we make that offer and the insurer fails to accept it, and we do better than that at trial, the verdict is higher than that when we get to trial, then the insurance company has to pay interest on the demanded amount, but the amount we offered to settle for, between the time of the demand and the trial. And so that's a pretty powerful tool, particularly now as interest rates are going up. So we demanded $519,000 using those two statutes and put a time limit on it. And within the limit, the insurance company accepted and said, yep, even though our limits were only $100,000, we're going to pay $519,000 to settle the case. So the deal got done, and we had a happy client.